Now to more details on the breaking news that we first told you about at the top of the hour. A judge has ruled that Catherine Hoggle, the mother who is accused of killing her two young children, is competent to stand trial.
And joining us now to help sort through the details of this case is David Felsen, Hoggle's defense attorney. David, thank you so much for being with us. We know our producers reached out to you just a short time ago.
It's nice to be with you.
And first, this is a major ruling. This comes after years of back and forth. What is your reaction to the decision?
Well, we're disappointed in the decision, but I have to say we respect Judge Bonifant. We respect his ability to analyze things, and we respect the court's decision. I don't agree with it, but I guess that's what makes me a lawyer, and that's what makes him the judge.
Can your team challenge this new competency finding, and if so, how?
Well, let me say this. For the first time since 2014, Ms. Hoggle, Catherine, is now the one in charge of her case. She is the one who makes decisions about what happens next, about how things proceed, about strategic decisions, what issues would be presented. There is an opportunity for appeal. I can tell you that we have not discussed that in any way. The ruling was sometime around 2:15 today. She was ushered out of the courtroom. We'll have to talk about that and see where she wants to go.
And David, for years, Catherine has been consistently found to be incompetent. During this week's hearing, there was a split decision there on her mental health status. Today, a judge ultimately weighed in. Is there a potential for the defense to argue her mental state has either worsened, either before or during the trial? And could that impact how the case moves forward?
Well, as everybody has agreed, and Judge Bonifant mentioned today, competency is fluid. Things can change one way or the other. Obviously, according to the judge, they changed in favor of competency based on this hearing. Could things change and result in incompetency? That is certainly possible. We are dealing with someone who has a profound mental health circumstance, diagnoses of which everybody agrees, profound and significant diagnoses that have affected in the past her ability to function, her ability to be competent to stand trial, separate from her ability to function. So those things are always fluid. Could they change? There would have to be a factual basis, obviously, to demonstrate the change, but certainly that could happen, yes.
And will Hoggle's mental health history be a significant role in your strategy in this case moving forward?
I can't speak to anything that's going to happen necessarily in the future. I am, as I said earlier, Catherine is now the one who controls this case. She is the one who makes the decisions. I will tell you in a different context, it would be unusual that somebody with Catherine's history and diagnoses that would not become a factor. Mm-hmm. The state has made it a factor in the case. We haven't talked about it yet, but the state's attorney has made it a factor in the case. I believe that some of the allegations in the case involve Catherine and where she was at various times and what she was doing concerning her mental health and her health care in general. So those have already been put on the table. Certainly not by us, but they've been put on the table. Would I expect that they will continue? I think it's a good bet, but I can't say for sure.
And the state is estimating this may not go to trial until about 2026. Is that the timeline that you understand to be working with?
I can't speak to the timeline specifically. I don't know why the state, well, it's certainly not going to go to trial in 2025. I mean, that would be in the next month. So 2026, could it be 2026?
Late 2026, yeah.
I don't know. It will depend on a lot of factors. I don't know what the court schedule is. I can tell you that I have other very significant cases that are being set much farther than 6 months down the road. So even if we were to pick the 6-month point, that would be June, mid-June, I guess. I don't think this case will be tried by then, and I would expect that it would be longer, but I can't say for sure.
All right. Defense attorney David Felsen, thank you so much for joining us today.
Nice being with you.